Go.
Yep, people are coming in.
Oh, yeah. Yep. Morning, everyone. Just gonna wait for everybody to be admitted, and then we will get started in a couple minutes.
Exactly 11 right now, so we'll give it a minute.
We're still popping in here. Here, one more minute, probably, and then
Yeah,
we'll
do you want to
get started.
let everyone know how they can ask questions or
Yeah, I was gonna make that
whatnot?
announcement. Wait for a
Great.
few, wait, give it another minute. People are still, I can see the numbers are still ticking up here, so
You're very popular.
yeah, this is a good one.
Um, Also, we're gonna send out the slides so we can let everyone know that as well.
All right, seems like the people popping in are starting to slow down to a trickle here, so we can get started. Morning, everyone. Thank you very much for joining us today. You have Matt Gaines, Seth Barnett, and Mark Einhorn, all attorneys here at MEEB. We are going to use the Q&A function in the Zoom. So if you have any questions, type them in there. We'll try to answer them as we go. You know, we will probably hopefully stick to the slides, but we'll keep an eye on that and try to answer them as we go along here. I am sure that most of you are joining to learn about the implications of the recent Texas District Court decision. I promise you we will get to that, but in very short order. So, and these slides will be emailed out afterwards if you signed up, and the presentation is always available on our website within a couple of days, I think. So if you want to share it with anyone else, whether it's in your association or anyone else, you can find the link to the presentation on our website within a couple of days or less, actually. So just a kind of a very quick recap. Again, not that anyone probably needs it, because I'm sure a lot of you have attended multiple webinars already on this topic, but you know, what is the Corporate Transparency Act? How did we get here? And obviously, you know, what's next, we'll get to very shortly. But, you know, the whole purpose of this law was to prevent money laundering, tax fraud, corruption, you know, financing of terrorists, and just sort of general financial crimes. The idea being maybe if you can get sort of behind the curtain on some of these corporations and LLCs, you might have a better idea about, well, how they're handling their finances. And so that is what the law was intended for. It was implemented by the Department of Treasury. This is a federal law and within their financial crimes enforcement network. And again, just really brief, you know, there's sort of something called a reporting company, which is, you know, any type of corporation, LLC, or other entity that's created by the filing of a document with the Secretary of State or similar office. That is a reporting company. There's a whole laundry list of exceptions that we won't go through, but for the most part, any company or entity has to report. And then also not just the company has to report, but the so-called beneficial owners must report as well. And that is anyone who directly or indirectly exercises substantial control over the company, or anyone who might own at least 25% ownership interest of the company. So as it pertains to, you know, condominiums and HOAs, we're really talking about obviously the governing board. And if there happened to be an owner who own more than 25% of the beneficial interest, they would be a beneficial owner and have to file the report with FinCEN, which again is really just filing your driver's license information and some additional information. That's what it is. I'm really going to keep it brief on that because I think now we'll get to really why most people are here today, and that's to talk about the major development that happened this week in Texas. And for that, I'm going to turn it over to Seth Barnett, who can give you the really down and dirty on that court decision.
Sure. Thanks, Matt. So on Tuesday, and this was a case that wasn't getting much attention nationally, and there's been a lot of national attention with the CTA, and I know that we've sent out newsletters kind of keeping you updated through all the legal progressions, including our case, which we'll get to, which before Tuesday I would have said was the most important case we've had filed. But I think at the moment, this Texas case kind of takes the cake and trumps everything. So in Texas, there's a challenge, and it wasn't a condominium challenge. It's a challenge by a group of businesses, political organizations, and trade organizations that represented about 300,000 members total, and they sought to declare the Corporate Transparency Act as unconstitutional, saying that Congress has basically overstepped its powers in enacting this law for a variety of different reasons. Now, as far as we know, and it's been reported, there's 3 other similar challenges across the country. There's one in Alabama, which has also been successful, and the court has found that that's likely to be unconstitutional, but that only applies to the specific group, a small business association in Alabama. There's been a challenge in Oregon that's been unsuccessful to date, and there's the one that CAI brought on behalf of condo associations everywhere that was unsuccessful at the start in terms of getting an injunction. But this week, an injunction was granted in Texas. And so what does that mean? This is unique in the sense that this was a nationwide injunction. And you may have heard a little bit about, certain lawyers, news organizations, whatnot, are questioning how that applies. What does that mean? Can they really have a nationwide injunction that comes out of Texas? Does that apply to all of us in New England here? And the answer is yes, it does. And it's clear that it does. And what this injunction does, and this judge said, is that this judge believes that the CTA and the government have overstepped their constitutional powers in enacting this law, and that he has enjoined the enforcement of the CTA and also stayed the reporting requirements, which become due on January 1st. And this does apply across the country to any entity that thinks they should have filed, is questioning whether they have filed, knows they had filed. And so there's this question about, well, how does this national injunction really work? And so I kind of went back and I just looked at this really briefly because national injunctions are like, they've become a really hot topic in the last 15 years. And so 96 times since Obama went into office, a circuit court in the country, a federal court, has granted a nationwide injunction. And basically, these range from immigration policies, where someone's gone to a Texas court or a Virginia court or a Maryland court or an Oregon court, and sought a declaration that a policy of the government that one of the presidents was trying to enforce or a department was trying to enforce was unconstitutional. And the court has said, because of the nature of this issue and the impact it has, we are halting this nationwide. That's happened with access to abortion medications, Title IX regulations, COVID vaccines. Recently, this same Texas court enjoined the enforcement of a non-compete ban nationwide. So this is a common thing that is happening across the country, and it's become sort of a political tool, but it's happening, and it impacts, just because it's in Texas at the moment, it impacts everyone. And the court's decision says it 5 or 6 times over and over again. This is a nationwide injunction. So the question is, why everyone's probably here, and is, what does this mean and what do we do next and what could happen? So what could happen first is this could be appealed. It probably will be appealed. The one in Alabama, which was several months ago, and there's an injunction that is only specific to those plaintiffs in Alabama, that one is on appeal. And that's been on appeal since March or April. And there's still no decision there. In Texas, the government could ask the court to let us have this appeal, but don't stay this injunction. I think that'll cause a lot of confusion. They didn't do that in Alabama. I'm not convinced they'll do that here. We monitor the docket to see if that happens. It hasn't happened yet. It would probably, if it was going to happen in a couple of days. But as of now, this injunction is in place. And an appeal takes a bit of time. In the CAI case in Virginia, the CAI has already brought their appeal, and the government has until I believe January 31st of next year to file just their opposition to that appeal. And so that's going to take a while too.
So just if I can interrupt just for one
Yeah,
second.
please.
Thinking about the appeal process, and obviously the deadline to file
Yep.
is before January 1, 2025. It seems unlikely that even if there was an appeal and this order was reversed or overturned, that deadline would still be the deadline. It seems to me that there would have to be some further push out of that date.
Yeah, I agree. And I mean, and you can even tell there's senators who have been speaking even before the decision came down, thinking that with all the uncertainty and the challenges, it takes an act of Congress, but they're even trying to extend the deadline up to a year just because of this uncertainty. There's that discussion going on. But given we're 3 weeks out, there's holidays coming, there's a new year, I would be shocked if stranger things have happened with the courts, but I would be shocked if that deadline changes. So the question is, what does this mean for us? What should we do? And that's kind of what we're going to get to at the end as we go through this. But if what we thought we would do was kind of walk you through all of these different legal issues and these recent litigation pieces, and then get to kind of those questions. And because I'm seeing them, there's a lot of them about what are the implications for this. And one of them is, how does this even involve condo associations? And I think that's a perfect place, Mark, if you want to kind of mention how condo associations even got involved in this.
Well,
Sure.
yeah, there is one question which I think is somewhat relevant to at least the slide. And it says, are there any implications, and I assume it's referring to this Texas case, for those of us that have already filed? I would say no, in the sense that, I mean, the government, you've already filed, so the government already has your information. That's unfortunate. They're not gonna, give it back, so to speak. It is there, it is filed. There's nothing else you need to do right now, but there's nothing else you would need to do anyways if you already filed. There are requirements under the law, which states that, again, for a board, a condo board, that if there are changes on the board, you're supposed to update that, within 30 days of the change. So if in the spring, you have your annual meeting, or a board member resigns, or otherwise there's a change on your condominium board, if this Texas case had not just happened, then you might have had to file an update to that. But because this Texas case did happen, and unless there's any type of change or anything related to that, I would say that you don't have to file your update in the spring, or if there's a change. Again, unless there's something that happens with the Texas case. Yeah, do you want to take it? Do you want to go to the next slide?
Yeah, I was going to add that there's actually, even if there's an exemption, let's say the Texas case is overturned, the order, but then there's an exemption that comes out of the new administration, there's actually a way to file, if someone had already filed their report already, to file as a now exempt reporting company. So that's another option.
Someone had just asked if, before we move on, because we were talking about the deadline changes, if we were shocked that it changes or doesn't change. I would be shocked if the deadline stays the same.
Yeah.
If this injunction was lifted next week, I would be shocked if they said you now will have this 10 days.
Yeah, because I mean, people are obviously going to claim that, well, based on the Texas decision, I was all ready to file, but I decided not to. And so I don't see how you could keep a January 1 deadline, because people are gonna say, well, I elected not to file, I threw away all my paperwork, whatever it is. So I would think that they would have to push out the deadline at the very least, but who knows?
And we'll
I-
kind of get to at the end the penalties that, are out there, and they're much talked about, and kind of what we think about them and some of the language in them as to why, as long as you're putting forth a good faith effort here and trying to do the right thing, well, you should be okay.
Okay.
All right. Well, obviously, in light of the nationwide injunction, currently there's no reason for an association or any other entity to file. So for now, the takeaway here is let's just wait and see how everything plays out. I think I mentioned there's a new administration coming into office. That may factor into whether or not there'll be a need for associations to file in the future. But for a minute, let's assume that this stay is lifted and that, the new administration or Congress does not provide an exemption for homeowner associations. We still think that condominium trusts and unincorporated associations are still in pretty good shape, and are actually not covered under the CTA regulations. In many states, condos and homeowner associations are formed as corporations, but in Massachusetts, that really is the exception and not the rule. The vast majority of associations here are formed as trusts. And a trust, whether it's an estate planning trust or a trust set up to manage property held in common ownership, like a condominium, that's formed by signing a declaration of trust. And typically in the condo context, the declaration of trust is then recorded with the registry of deeds. But recording the trust does not create the trust. And going back to the language Matt was talking about, used to define what a reporting company is, a reporting company is an entity that's created by filing a document with the Secretary of State or similar office. And a condominium does not fit that definition. Below or on your screen under the heading there, FinCEN published answer to try to answer whether homeowner associations are covered under the CTA regulations. And their response, although it's not on the screen, began with, it depends. All right, so what does it depend on? It depends on whether the association was created by filing with the Secretary of State or similar office. And their response also goes on to say that an incorporated HOA would be covered unless there's an exemption. So not the best answer by far, but it's clear that FinCEN obviously recognizes there's a difference between incorporated associations and those that are not incorporated, which begs the question, what the heck is a similar office? On the second part of the screenshot there, the slide, FinCEN attempted to answer that also, trying to define what a similar office is. And the response says it's any office of government authority where a domestic entity files to be created to do business in the country. So could someone try and make an argument that the Registry of Deeds is a similar office as a Secretary of State? It's possible, but you really have to stretch to do that, because a registry of deeds is generally known as a place used to provide record notice of title, not an office which creates entities. And a condominium is not an entity. It's a form of ownership, and the entity which operates the condominium and can do things like contract for services or sue and be sued, for example, that's the association of the trust. So by the plain reading of the regulations, condominium trusts and unincorporated associations do not fit the requirements for a reporting company. Matt's going to talk about this later, but because they're rather scary sounding penalties for non-compliance with the CTA regulations, our firm wanted to seek further clarification so that our clients could be more comfortable knowing that the regulations don't apply to them and they're not going to be, hauled off to jail for non-compliance. which brings us to our next slide. And Seth is going to talk about the federal case he brought on behalf of our client, which is Lewis Wharf.
Thanks. So to Mark's point, we wanted some clarification. First from the government, and we tried, and everyone has tried. CAI has tried, countless attorneys have tried to get the government to tell us one way or another what types of condominium entities are covered or not covered by the CTA. And the government simply won't answer and gives you that "it depends" language. So in talking with some of our clients, we decided that it was best to try and see if we could get a federal court to answer this question for us. And the litigation that we brought is different from the litigation I just talked about. Those are constitutional challenges to saying the CTA itself is unconstitutional. It should have never been enacted in the first place. It's government overreach. We decided, okay, since those are already been filed and those are making their way through the courts, let's see if we can get a court to declare that, specific to Lewis Wharf, a condominium created in accordance with the statute, a condominium trust, is not covered by the CTA, does not have to comply with its requirements. We were not seeking a so-called exemption from the CTA. We were seeking for a court to declare that we are not subject to it, that the plain language of that statute that Mark went over, we don't fit within that statute. And so you've probably heard from others in news articles and whatnot that we lost this case. This case was dismissed. That is true. This case was dismissed. I'm going to characterize it, and I wrote it and argued it. This is a win disguised as a loss. In this sense, we argued that exactly how Mark laid it out, that this was a condominium created pursuant to the statute, it was a declaration of trust, and it was ultimately recorded for notice purposes with the Registry of Deeds. It was not incorporated and it was not registered with the Secretary of State. The Department of Justice response was, well, if that's true and we have no reason to doubt it, then you're right, you're not covered by it. But because you're not covered by it, as a matter of law, you can't bring this lawsuit. You can't challenge a statute or seek an opinion from the court when you're not subject to that law or that enforcement regulation. And that's true. That's an advisory opinion from the court. That's true. We knew this going in, but we thought we would take a chance at it anyways. And we tried to still convince the court, well, this is a little different. You should still give us that declaration and that opinion. And what the court did was it agreed with the government, but in agreeing with the government, it recognized that both MEEB and Lewis Wharf and the government agreed that based on the facts and how Lewis Wharf was created, it is not subject to the Corporate Transparency Act. So we got from the, it wasn't a slam dunk decision because it wasn't a declaration from the court which says condominium trusts and unincorporated associations are not covered by the CTA. But what we got was we got language from a judge who says the parties agree that Lewis Wharf is not covered, and I have no reason to question that. And because of that, I agree they don't have standing to bring this. So the basis for the judge's decision was there is no disagreement that this condominium trust is not covered by the CTA, and therefore this case doesn't need to go forward.
Yeah, you know what's interesting, Seth, is that the government attorney, the U.S. attorney, also cited to our condo statute in Massachusetts saying, well, the statute says that A, you don't have to record a trust or bylaws, and B, they have to be in existence when the master deed is recorded. So there's, yeah, you're right. It is a huge win disguised as a loss because it's basically saying, okay, we were saying, we know it, we don't think it even applies, but do you agree? And guess what? When they're given the opportunity, They did agree. The government did agree. That's what they said, and that's why it's significant.
You know, and look, when we first filed this spoke to the government attorney a lot, and we tried to, we asked for originally what you would do is to enter into an agreement or a stipulation. The government was unwilling to do it, because the government doesn't like to concede anything, as they told. And his point was, well, if it doesn't apply to you, you don't need the stipulation. The case should just be dismissed, and that's going to be enough. The other thing, and we'll get to, is they said, I said, well, we'd really like that because our client's concerned. What happens if they don't file? Are you going to come after them? And he said, and I'm paraphrasing, is that's not the interest of the government to come after condo associations chasing them for filing. And as hard as I pressed him to somehow put that in writing somewhere, we obviously don't have that. But I'm comfortable having that conversation with him and sharing it with everyone here. But so that's where that litigation left off. We haven't decided to take an appeal of it. We're comfortable with that decision. We're comfortable giving you the advice that Mark, gave a few minutes ago, that the plain language of this statute does not apply to unincorporated associations and condominium trusts as it's written. I don't, and there's a lot of questions I'm seeing about the intent of the government, and this seems ridiculous and an overreach that they're really concerned with condominiums regardless of how they're formed. And that I think we would all agree. I think every condominium attorney would agree with that. That's CAI's, larger lawsuit. That's clearly the intended purpose and the intended argument of that from what we've read. But this was a little more narrowly focused, trying to address kind of Massachusetts condos and how they're created. And I think it's probably, a good time to move to kind of some of those last things and then kind of get to more specific questions that I think we're all seeing on the screen, and they're kind
Just real quick, and I agree, like the obviously the regulations were too broad. It's called the Corporate Transparency Act.
Yeah.
I mean, it started with that. So
and it's the purpose of it is anti-money laundering,
right, in commerce, which condominiums are not engaged in. But needless to say.
So just really our final slide, and then we'll get to a bunch of these questions, is that, if you don't comply, what are the penalties? Again, arguably you don't even have to comply at all because of the Texas case, but if something gets overturned or the stay gets lifted on that, these are the penalties. There's fines of $591 a day, a $10,000 fine and 2 years in prison. But as I understand it, is that this is all for sort of willful non-compliance. It's not just saying, well, I didn't, comply because I didn't know I had to, or whatever it was. It's for willful non-compliance. And kind of going back to what Mark and Seth were just talking about, in that our opinion, even before the Texas case came out, really more based upon our case, the Lewis Wharf case, was that this doesn't apply to condominium trusts and unincorporated associations because they're not created by the filing of a document with the Secretary of State or similar office. And so that is the opinion that we've been giving to a lot of our clients over the last couple of months. And in our opinion, an association is entitled to rely upon the advice and opinion of its counsel. So if you choose not to file because your attorney told you didn't have to file because the law doesn't apply to you, that's not willful non-compliance. That's not complying, but you're not complying because your attorney told you that, and you're allowed to revise on advice of counsel. So we feel that an association would not be fined in that circumstance. The government might say, well, this does apply. Then you could say, okay, I guess our attorney was wrong, and then you would have to comply. But again, the penalties are really only for willful non-compliance. So I wouldn't be overly worried about it. Not to mention, I think I saw an article the other day, or Seth, you sent one around, that said there's something like 32 million corporations and entities that are likely kind of fit within the CTA and aren't exempt. I don't know how the government in any type of efficient manner is going to figure out, which of those 32 million have submitted and have not. So, it's a mountain of paperwork for the government.
It sounds scary. Yeah, go ahead, Seth.
I said to someone about that 32 million number, if they can calculate that there's 32,600,000, expected filings, it would be nice if they could tell us, does that number include condo associations or not? You know, if they can calculate the number, we could tell them how many condo associations are, but they won't.
Yeah.
Real quick, Mark, on the willful piece, I just thought it, you know, because willful is a legal term, and it's usually used in the criminal sense. And it's essentially, it's, you have to be deliberate and intentional and knowingly fail to comply. That's a lot different than if you missed the deadline by 5 days, or you relied on the advice you're getting here from any of us or your management company, or saying, oh, I heard there's this injunction, I'm going to wait and see. If you wait and see and then file after, you're not in willful violation of any statute. You're relying on a legal opinion. And I think you can, I think we would all agree on that.
Yeah, and right now, until and unless that order is overturned, there is no enforcement permitted. And there's no deadline to file, no requirement to file for any entity, whether they're a corporation or a condo association. I know you said that, and I said that already. I just want to make it clear that right now, with that order in place, there is no reason to make any filing. If that order is lifted, and there's no exemption, then associations can decide, okay, do we have to comply or don't we? Is it worth even? It's very easy to comply, and we've done a webinar about how to file. It's very simple. So some associations probably will say, you know what, we'll file anyway, even if we don't believe we have to. But some may not want to. But I think that's not even on the table right now until the order is lifted, because right now there's no requirement to file.
Why don't we get to some of the questions here? So the first one, it's actually a good question, is that should the CTA end up being required, and that some of this case is overturned or this stays listed, what do we do if we have a 5-member board, but one of the board members refuses to provide their information?
Yeah, that's interesting. We haven't had that come up yet. I'm sure it will. You can theoretically, they being a beneficial owner, have an individual obligation to give the information necessary for the reporting company to file. And theoretically, you could seek legal action and get that in order for them to do that. And possibly other penalties. In the real world, the real condo world, we would never advise that. And it goes to a willful violation. We would say, and I think this is the best practice, that you file with the information that you have. You try to comply as best you can. You certainly can request the information from the board member, maybe some other steps, but you would ultimately file with what you have and try to comply as best you can.
Give as much of that person's much of that information that you have, and there's a lot of people who are concerned about, I don't want to give the federal government my license if this becomes enacted. Mark, can you, because you know a little better than I do, touch upon, like, there's an option that you can avoid doing that in certain aspects.
Yeah, there is. And just one before I get to that point, with regard to trying to comply, FinCEN itself has put out guidance about the issue of someone withholding information. And essentially what they said, in addition to what we just stated, was that they know this regulation is new, that they know there's a lot of education that's going to need to happen. And they're basically telegraphing that they're not going to be policing this, like if you failed to, file taxes and you had $1 million profit or something, they found out about it. So that's one thing. Getting back to your point, Seth, if your board is going to file, and if you have a board member that is objecting to giving their personal information from their license, maybe to another board member, to their manager, or to a third party, there's actually a mechanism they can go on to FinCEN by themselves, upload their information, their license, and in return, they can get a FinCEN identification number. Once they have that number, that can be used on the beneficial ownership interest report. So in lieu of providing their information directly to someone else, they can just give that number, which is a great way of circumventing having to, if that's what you're concerned with, having to give your license, a copy of your license to someone else.
And I think that the big takeaway too, at least in terms of the information, is that it's really for the individual board members, it's really only the information on your driver's license, which the government, at least the state government, already has anyways, because they issued your license. And it's no more invasive than if you were to be applying for a passport through the federal government or anything like that. So I think the concern about the government getting my information, I think it's a little overblown, particularly that it's all just what's on your driver's license and the government already has that information anyways. Next question is a good one, pretty simple question though. Is it, would a board member's spouse need to be included in the FinCEN filing if the spouse is also an owner? No, it's only the board members because they're the only ones that have direct control, not the board member's spouse.
Yeah, the only exception to that would be if to qualify as a beneficial owner, it's whether you exercise substantial control or you own 25% or more of the
Right.
entity.
Yeah. So right.
Yeah, in some crazy, in a weird situation, if an owner owned 25% or more, they might have to register even though they're not on the board.
Yeah.
Yeah.
The next question I think we've talked about was, does a condominium that is a trust need to file? So again, if you asked us that question a week or 3 days ago, we would have said no. That's our opinion because a condominium trust is not created by the filing of a document with the Secretary of State or similar office. But particularly after the Texas case, no one has to file anyways. Do you anticipate any penalty to the associations if the Board of Trustees does not file? We just kind of talked about that. Again, it's really only for that willful non-compliance. And in light of the Texas case, if you don't file, that's certainly not willful compliance because you're relying upon, that recent court decision. Should associations that are already required to file with the Secretary of State still expect to file?
That would be,
Again, if you ask me
you
that question,
can,
yeah, if you
because
ask me that
there's,
question a week
you don't
ago,
have to in the moment because of this Texas decision.
right?
You can, as Mark said, and Matt said, it's easy to do. There's no harm in the wait and see. I know people are concerned that the deadline is, January 1, 2025, which is 3.5 weeks away. But our recommendation has been to wait and see, especially in light of this decision. Reading this decision, it's a pretty strong, heavy-handed decision that really comes down hard on the government and the way they've put this law into place, and it's questioning, whether, the powers of the government under the Commerce Clause and other mechanisms. But really, it's this is, a lot of people think this is things that states are already doing. We're already regulating businesses and filings at the state level, and that these are things that can be done. And that's a lot of the criticism there.
And there are, Matt, you probably have a little bit more insight in this, but there are still pending, bills.
Yeah, no, there's
that,
still,
that have a good chance,
yeah, I mean, obviously we're in the waning days of the congressional session here. It ends, right just after the new year. But yes, there are still some bills out there that would, extend the deadline, kill it altogether, exempt someone that is specific to
the reality is there's a new administration in a month coming in.
Yeah.
And they may not enforce this. They may direct their DOJ to take no action in terms of any appeals on it. It's tough to say. I mean, we are moving from one view of government to another. So, we may get a different result at that level, at the legislative level.
Yeah. Next question is, what if an HOA is registered as a nonprofit corporation with the Secretary of State? So again, if you asked me that question 3 days ago, I would have said, yes, you actually do have to file because you are an incorporated corporation. You would have to file. But again, based upon the Texas case, there appears to be a stay for all reporting companies. So at the moment, no one has to file, no matter what.
Yeah, there's an exemption also for charitable organizations, but being nonprofit is not charitable.
Correct, right, exactly. Yep. There's a question about Rhode Island. It says, I'm in Rhode Island and many of the associations we manage are unincorporated. I'm wondering if your example of a trust in Mass applies to a declaration of condominium in Rhode Island.
Yeah, we think it does for the same reason. When bylaws don't have to even be recorded. And it's the same rationale that you're not creating that entity by filing with the Secretary of State or a similar office.
Next question is really about the filing and, what concerns, if any, are we hearing from associations about the filing itself? It's touted as being easy, not a lot of time. Is the concern that it's an overreach, bureaucracy, invasive, intrusive, what else? Yeah, I mean, I think the actual filing itself is not that difficult. The only difficulty is that you have to file everything at once. So if you have 5 board members, you have to get all their information together, all their driver's license, etc., and file it all at the same time. It's not like, if Matt, Seth, and Mark are all on the board, it's not like Matt can do it, and then, 2 days later, Seth can log into the same account and do it, and then Mark can do his a week later. You'll have to do it at the same time. So that's the only thing that's a little bit of a pain, is to get the information all together and do it all at the same time. But other than that, it's not that, excuse me, it's not that difficult. As I think Mark mentioned, on our website, we have a free portal that you can use, and we've tried to make it as user-friendly as possible, going step by step, the boxes you have to fill in and check, and what you have to upload. So the filing is not that difficult. It's really just making sure you have all the information.
The only other thing I would add to that we hear is that the concern is that, you have to keep this information updated with board member changes and whatnot. And that does seem, there's a level of frustration with that, knowing that you have to continually do that. So, and that's part of the reason, people are there's challenges. There's a, challenge CAI's suit is challenging it. And part of the reason is, and what we've heard from clients is, look, people don't want to serve on this if we have to keep doing this. That is a reality of it. And I'm sure that you're hearing it at your condo levels and your management company levels as well.
Yeah. And someone just asked, by the way, if we're going to keep that portal on our website open. Yes, I don't think we have any plans to take it down. I'm sure if you want to file, even though arguably you don't have to under the Texas case, I'm sure the government will be more than happy to still take your information. But yeah, so we have no plans to take our portal down. You're welcome to continue to use it.
And we've had just in terms of I guess information, we've had a few hundred associations file through that portal by themselves with no issues, relatively few issues. And there's pretty detailed instructions there. So by all means, if association, if the stay is lifted and associations feel like, why not just comply, that certainly can do that. It's FinCEN puts out in their responses, you do not need an attorney to file. They never anticipated that this would be a task for an attorney to enter beneficial ownership information. And we certainly don't think so either.
Yeah. There's a question about Maine, and that someone noted that Maine law is very different from Massachusetts. I assume they're referring to how condos or HOAs are organized. And they weren't sure if it applied to them. Again, the Texas case would still apply, but as far as, the unincorporated association trust, neither Seth, Mark, nor I are admitted to practice in Maine, so we probably can't answer that. I would note, though, however, Justin Magzarilli in our office is a Maine licensed attorney and does represent some Maine condo associations. So you could talk to Justin. He works out of our New Hampshire office.
And if you shoot us an email on Maine, any one of us, we'll get you in direct contact with Justin as well.
Yep. Someone asked, does a required filing of a tax return of an 1120H or 1120 make a difference? No, that's, again, I know a little bit about, condo tax returns, and you can file either the 1120H or the 1120 for associations, but electing one of the other does not subject you or not subject you to the CTA. It's all depending upon how the entity itself is organized. Let me see what else here.
You're doing a better job of any of us keeping track of these matters.
Yeah, I appreciate it, man.
No problem. No problem. So someone asked, what's the best way to be updated on how this progresses in the event that compliance is deemed necessary for HOAs? I'm assuming if you signed up for this webinar, you're probably already on our newsletter list, our e-newsletter list, but that's a great way. We are on top of this stuff. Seth has been tracking a lot of these cases all around the country. We got that decision, I think, at, 1 o'clock or 2 o'clock, moments after it had been issued, the Texas case, we all digested the 79 pages and, put out a newsletter within 12 hours, kind of dissecting that. So if for some reason you're not on our newsletter list, because maybe someone forwarded you this, feel free to email any one of us. Our email addresses are all on the screen right now, and we can add you to that list certainly so you can get any updates as this progresses.
See a bunch of questions about LLCs if.
Yeah, feel
Mark,
free.
you
If you guys
wanna-
want to jump in, I'm kind of just
Yeah,
trying to take questions that we have on different topics a little bit here, so I'm
Yeah.
just cruising through here. But if
What's
you
the LLC question?
yeah. Condos that are also registered as LLCs, associations that are registered as LLCs.
If an association is a corporation or an LLC, absent, an exemption or this ban not being in effect, right now they would have to file. But they don't have to file. No entities have to file. Corporations, LLCs, any entity does not have to file under the current order. And, we'll see how long that order is in place or see what takes its place.
There's a question about kind of going back to the Lewis Wharf, the Massachusetts lawsuit that we filed, and it was a question about essentially bringing a declaratory judgment action in to get standing. And I apologize if I kind of confused some people. So the case we did, it was a declaratory judgment action, and we're seeking a declaration that condominium trust and unincorporated associations were not subject to the CTA. And the court, as federal courts often do, said, because you are seeking what we believe is a federal advisory opinion, and because the statute is not yet in effect, and there's no evidence that or allegation it's being enforced against you, or you're subject to any penalties, and it doesn't even apply to you, we don't believe you have standing, or there's no subject matter jurisdiction. So that's kind of what was somewhat anticipated, in the sense that the federal courts continuously put out these decisions that say we're not here to give you advisory opinions. Your attorneys can answer those questions. And we did. And we were trying to see if we could get more information and further declaration. But the court, and no court has done it yet. We came close enough that we feel comfortable telling you what we think you should do. But the answer was the court was not inclined to give a declaratory judgment.
Yeah, and Seth, I've had the question of, okay, well, given the government's position taken, could the government in a different case, argue, I guess, in the opposite way, that a condominium trust is covered? They could. There's absolutely could. But is it likely, right? And does it fit within the plain reading of the statute? Or can they make that argument? And you can put forth the argument, it's possible, anything's possible, but we don't think that's likely.
We've obviously been mostly talking about condos and HOAs. There was a question about would cooperatives be required to file? Yes, so all cooperatives are incorporated. So if the stay is lifted, any cooperative would be required to file.
I saw an interesting question pop up, and the question is, in the given association, the unit owners actually vote to approve or not approve the budget. And the question is, would that make all the unit owners beneficial owners? I hadn't actually considered it. Thinking about it now, I don't think so, because they're not managing, essentially exercising substantial control. That's an approval, ultimately of a set amount of money, but they're not actually allocating or performing the day-to-day tasks. But good question.
Another question is that if the association has, kind of related to your question, Mark, if association has to file, would the treasurer have to be part of the filing if they are not a board member, but just an officer? Again, so the definition of a sort of beneficial owner who has to report is someone who directly or indirectly exercises substantial control over the company. I guess it all depends on what's the treasurer doing. I mean, are they just taking
Right.
checks and depositing checks in the bank and paying your vendors? If so, then they're probably not really exercising substantial control. If they have a much more involved role, like a treasurer of an actual, corporation, they're obviously very involved. So I think you know, the safe bet, the conservative answer would be, yeah, probably just have them file, but you might need to drill down really on what their role is as treasurer.
And it's unusual that an officer wouldn't be part of the board also.
Yeah.
That doesn't come up very often.
Um, so one of the questions too is that if you know, again, one board member refuses to comply, would the penalties be against the association or the non-compliant board member?
So the statute uses the word person.
Okay.
And I think that's important. My career before condo law was civil rights law, and the civil rights statutes, federal statutes, when they use the word person, it means a person and not an entity. So you know, this is obviously it's a law that is not in effect. Hopefully, will never go into effect, but it does use the word person. It says any person that violates these subparagraphs shall be liable. So I take that on its face in the plain language of the statute, and it means person. That doesn't make this an easier thing because we're dealing with, you know, entities and who becomes liable. That may go to the issue of if there's somebody who willfully refuses to cooperate, it would probably be that person. If it's the entity yourself, you all decide we're just not doing this. We refuse to do this. You all may be subject to it as the person or people doing this, as the board, as an entity. But the statute uses the word person, which makes it difficult because we're dealing with entities.
And I think their FinCEN might have some information about that too, at least not outside the statute and their guidance. And I'll have to look into it more, but I believe they say, you know, first, an individual and the entity are both responsible.
And I
Essentially.
think it has to be that, you know, even though it says the word person. One thing to know on the so-called penalties, there's kind of a safe harbor provision in there that if you forget something or you file something inaccurately, you do have 90 days to fix it. You're not going to be subject to a penalty, which is different. You know, that's kind of, you screw something up, we generally refer to as negligence. You're not going to be subject to a civil penalty for negligence, for an error. So,
I'm just going to ask this question. It's definitely been discussed, but I think it's a good kind of summary question as we sort of near the end of the hour here. Is that if a condominium is in fact a corporation filed with the Secretary of State, you recommend they still wait or do they file? I think our recommendation is that, again, based upon the Texas case, which put a nationwide injunction in place, stopping all filings, that a corporation does not, at this point in time, as we're talking, need to file. Again, things are changing fast, obviously, and that remains to be seen what happens if there's an appeal or if the stay is somehow lifted. But as we are talking at this moment, even a corporation, an association, HOA, condo that's organized as a corporation would not have to file.
Yeah, there was an article this morning in Forbes about this too, because it's trying to advise small businesses, and that's exactly along the same lines that if you know you're a corporation, your best course is not to file right now and to wait and see what happens with this regulation.
Again, kind of on this whole topic of penalties, if one board member refuses to file, good question here. Do you think there'd be coverage under the D&O policy for that penalty? I think D&O policies usually exclude fines and sanctions. So my guess is that the D&O probably would not step in and pay that penalty.
I don't think it would be considered a covered claim.
Yeah. Yeah. Let's see what else here. This was a so again, I have a seven-member board in my community. Do all board members have to file? Yes. So if the stay is lifted, everybody, all board members would be required to file the information. And again, you have to do the filing all at once. So you have to collect all the information from all seven and basically file it all at the same time.
All right, try to get a couple more in here.
Yeah, I don't know if you guys see any that were not, I'm trying to ask new questions here.
Couple questions about the manager's roles here. Does a property manager's own CTA filing cover them for the financial duties it performs for an association, or should we file with the boards?
So I think there was, Mark, wasn't there some opinion or guidance on this that as it pertains to a condominium association or an HOA, the management company is not a beneficial owner of that condo association. So again,
Right.
you have two levels here, right? You have the reporting company. So the company has to report its information. And so using company meaning the association, and then the beneficial owners of that entity, meaning the board or any unit owners who happen to own more than 25%. The property management company doesn't fall under that umbrella. However, the management company itself likely has to file just because it is a corporation itself. So you would have to file your own report, but you wouldn't have to file under the umbrella of the association's report.
Yeah, that's consistent with what FinCEN has put out in terms of, and they don't discuss property managers specifically, but they talk about attorneys, accountants, other agents of the board that are performing tasks and might be involved in decision making or advice. But because it's advice and there's no vote, as an attorney or a property manager, typically, we don't believe that a property manager would be deemed to be in substantial control. There could be a circumstance, or circumstances where that happens, but in the general run-of-the-mill case, we don't believe that would be the case for a property manager. How are we doing on time? Couple
Yeah,
more
we've
minutes?
got a few more minutes. Take a
Yeah.
couple more questions here.
Trying
Someone
to
just
find the
asked
open
that.
ones.
Sorry, go ahead, Seth.
No, I was trying to find the open questions, so sorry.
Someone asked, one member has filed, but the other members of the board have not because of this new information. I trust that will not be a problem. Right, it's not a problem right now because you don't have to file. So just, stay tuned, but for now you're all good and you don't need to file.
I think one of the broader questions was about the CAI suit and people's feeling that it's unfair that, condominium trust and an unincorporated trust, we don't believe have to file, but incorporated ones are covered. And how is that fair? We agree. I don't think any of us think it's fair. And I think that is what CAI is trying to do, and seek an exemption in addition to challenge the constitutionality, saying that this statute's not intended for condominium associations and community associations. This is not the purpose of the statute, as Mark talked about. There's no business for them to be covered by this. So there needs to be an exemption here, and that's what a lot of the legislative efforts have been as well. So I think we all agree. It's not fair. They all should be exempted, even though some of them aren't even covered by it, as we discussed. And our hope is that we get to that point one way or another. Because an injunction, the injunction I just want to mention it's called a preliminary injunction. That means the companies in Texas haven't won the case. All they've done is demonstrate they have a likelihood of success that they would prove their case of unconstitutionality. And so the court says, okay, based on that, you've met this it's a very high burden to get an injunction, and certainly a higher one to get a nationwide injunction. You've met this high burden, and we're going to put that in place until this court, or the way this is tracking, it might be the Supreme Court, decides whether or not this statute is constitutional one way or another. Certainly because where we have this split decisions among different jurisdictions across the country, it may very well be, if the government wants to keep pursuing it, it may end up with the Supreme Court for an ultimate decision.
I think that's a great parting words there, Seth. Mark, do you have anything else you want to throw?
Yeah, just the takeaway right now is wait and see. You don't need to file. I don't think and any entity should wait and see what happens with this. But right now, there's no enforcement and there's no requirement to file. We have been saying that pretty consistently since this came out, because for a lot of reasons, it was being challenged. It didn't seem to fit a lot of associations. And we were trying to fight to overturn it as well. But right now, I think we just wait and see. We'll definitely be monitoring, and we'll bring any updates that we find.
Thank you. And yeah, if
Thanks,
you guys have
everyone.
any follow-up questions, again, our emails are on the screen. Feel free to reach out to any one of us, and we're happy to help you guys. And stay tuned. I'm sure this won't be the last you'll hear about the CTA. So thank you, and happy holidays to everyone.
Thanks, everyone.
Thank you.